Good evening, everyone, and welcome to this special presentation with Tina Minkowitz on the impact of international law on mental health legislation. This program is presented in partnership with the Vancouver Unitarians, and we're so happy to see so many of you here tonight. My name is Raji Mangat. I serve on the Vancouver Public Library Board of Trustees, and I'm very proud to be a trustee of this wonderful institution. I'd like to begin the evening by acknowledging that we're gathered on the unceded homelands of the Coast Salish peoples, the Musqueam, Squamish, and Tsleil-Waututh nations. We thank the people of these nations for their hospitality. Before I introduce our host, I have just a few brief announcements. You are all warmly invited to return to this room next Thursday at 7 p.m. for the event launching VPL's Indigenous Storyteller in Residence program. The Indigenous Storyteller in Residence this year is Toits Tanat Cease Weiss. She is a media artist and ethnobotanist, and we're very excited about the term that she is going to be spending here in residency. At the launch event, she'll be honoring women of the Squamish Nation who have inspired her during her life with stories of the Great Fire of June 13, 1886. So that's happening next week, Thursday, in this very room at this time. So please do come back for that. More information about that event and about any of the other events that are taking place here at VPL can be found on our info table, which is just right here, or on our website, vpl.ca, and you can also sign up for an email newsletter if you haven't already, and then you'll get the information right in your inbox. I'd also like to remind you at this time to mute your phone so there isn't an embarrassing interruption. And if you do need to leave the room, please use the back doors, and restrooms are just outside these doors. Turn right and then walk sort of straight, and you can't miss them. In the very, very unlikely event that a fire alarm goes off, please just use any door you can and go out through the promenade. And please do not take any photographs tonight and no recordings. That's been a request that was made to us, so please respect that. And now I can finally start with why you're all here tonight. We are delighted to have Irit Shimrat with us this evening. Irit edited the national magazine Phoenix Rising, the voice of the psychiatrist. She co-founded and coordinated the Ontario Psychiatric Survivors Alliance and has presented 2 CBC Ideas radio shows exposing psychiatric abuses. Her book, Call Me Crazy, Stories from the Mad Movement, was published in Vancouver in 1997, and her work has been published in various books and magazines. Irit will be introducing our special guest this evening. Please join me in giving her a warm welcome.
Thank you, and thank you all so much for coming. It's wonderful that you're all here. Tina Minkowitz is an international human rights lawyer and a survivor of psychiatry who took part in the drafting of the Convention on the Rights of Persons with Disabilities, the CRPD, as representative of the World Network of Users and Survivors of Psychiatry. She is founder and president of the Center for the Human Rights of Users and Survivors of Psychiatry, and travels extensively to raise awareness and improve understanding of the CRPD, to which Canada is a signatory. The little pieces of paper we've put on the seats are for writing down any questions you may have for Tina. We will collect them after her talk, and she'll respond as time permits. And on the back table over there, there's a bit of free literature that we've produced on related topics that's going fast. Also a sign-up sheet for those of you who want to be informed about future events regarding psychiatry and human rights. So please join me in welcoming one of my personal heroes and someone I'm very proud to call a friend, Tina Minkowitz.
Thank you so much, Irit, for that warm welcome. Thanks for inviting me here. Okay, let's get right to it. We're going to talk about impact of international law on mental health legislation, and of course that specifically is the impact of the Convention on the Rights of Persons with Disabilities. Prior to the CRPD, the standard in force in international law was called the MI principles, the principles for the protection of persons with mental illness and for the improvement of mental health care. As you can see probably from that title, it was a kind of international standard that looked like the mental health laws that you're familiar with. It was a non-binding declaration of the UN General Assembly. I'm stressing non-binding, unlike the CRPD that we have now, which is binding international law. The MI principles, the most important distinction between that and the CRPD, we're referring to that as an old standard. It was regulatory and not prohibitive with respect to involuntary treatment and confinement, being locked in, being deprived of your liberty in the psychiatric institutions, involuntary commitments. The CRPD turns that on its head. The CRPD actually takes a stance of abolition, and I'll be explaining why and how that is in the text. So, as we know, domestic mental health legislation, everywhere in the world that it exists, is the same as what the MI principles does. Often they have a danger criterion and a treatment criterion. It might be that they can deprive you of your liberty through involuntary committal if the psychiatrist believes that you're mentally ill and you're dangerous to yourself or others, or potentially dangerous. It may be that they can have you committed if they believe you're mentally ill and in need of care or treatment, or if they believe you're gravely disabled by what they believe to be your mental illness. That's usually the way mental health legislation works. Another way that sometimes in mental health legislation or capacity legislation, people can get involuntarily into the mental health system is when there's third-party consent via a guardian. Also, there can be coerced voluntary admissions. In some countries, there's actually no mental health law, but people are pressured and effectively coerced by their psychiatrists, by their families, to enter a psychiatric institution and submit themselves to treatment that they don't necessarily really want. And we know that, of course, that happens where there is mental health laws as well. People feel that it may go easier on them, and they're told that it's going to go easier on them if you sign yourself in. Okay, and of course the involuntary status is what I'm talking about, the danger and treatment criteria and gravely disabled. The CRPD makes a full reversal of that. It guarantees full and equal rights to legal capacity, liberty and security of the person, and free and informed consent in health care. Legal capacity is the legal status that gives you the right to make decisions in any aspect of your life, including whether to have or not have a certain treatment. Liberty and security of the person has to do with whether the state can lawfully deprive you of your liberty, on what grounds and in what ways the state can lawfully deprive you of your liberty. That must always be non-discriminatory. And as we'll see, mental health legislation is inherently discriminatory because it's based on the idea that if somebody believes that you have this mental illness, what they call mental illness, if somebody believes that you have a condition that they think they can identify in you, that's a lawful ground to deprive someone of liberty. And the CRPD says, no, that's in effect discrimination based on a disability. And free and informed consent in healthcare is a human right. It's enshrined in most national legislations, but it's been deprived to people once a psychiatrist labels them. So how did we get the CRPD? What are its origins? One of the gentlemen who chaired the negotiation and drafting of the convention, a man named Ambassador Don Mackay from New Zealand, has said that the CRPD was 80% written by civil society, not by governments. Governments are the ones that formally negotiate the treaty, but in effect, it was disabled people's organizations, abbreviated as DPOs, including the World Network of Users and Survivors of Psychiatry, that contributed the substance of the text, the spirit, the life, and the vast majority of the actual content of the text came from organizations of people with disabilities representing ourselves. And WNUSP was right in there. We wrote our text proposals. We got them into the draft text and kept the essential aspects of what we needed throughout the negotiations. So it is in the final text, and we'll see what that looks like. I come from what we used to refer to as the ex-mental patient movement back in the old days, in the 70s and 80s. Some organizations started in the 1960s. Then we started calling ourselves psychiatric survivors or survivors of psychiatry. And we have always advocated the abolition of forced psychiatry. No matter what else we were advocating, those of us who came out and organized ourselves in that movement and found each other in that movement, abolition of forced psychiatry was a cornerstone of what we were trying to do. Many of us, including myself, saw ourselves as bearing witness to atrocity and wanting to say never again. And of course, it is happening again. And for many, it happens again and again and again. And that's really intolerable. The legal and political advocacy for abolition of forced psychiatry was failing. We had some legal allies in those days. We had, for instance, in New York, we had the New York Civil Liberties Union bringing lawsuits. I don't actually remember the details, but we had lawsuits that were trying to get psychiatric commitment declared unconstitutional in the US. And I don't know exactly what you may have had in Canada or other countries, but those advocacy efforts failed. And I believe that one reason they failed is, and they resulted in reforms at times, but not abolition. I believe that one reason they failed is because we didn't have, at that time, we weren't putting forward the concept of non-discrimination. We were saying, this is an atrocity. It should not ever, ever be done to anyone. You take away their freedom, you lock them away, you put them in these horrible restraints and isolation rooms, you inject them, you make them take mind-altering drugs that make them feel horrible. It's like, why on earth would you do this to anybody? And still, I think we didn't effectively combat the discrimination. We didn't name it as discrimination. We just said this is an atrocity. But because of the discrimination, because in the minds of judges and in the minds of legislators and the general public, the idea is, well, but they're crazy people, they're mentally ill people, you know, it's different for them. It's okay to treat, it's actually good to, you know, what we're doing is the best we can do for them. And so I came to believe when I encountered disability non-discrimination law that that was, that could be a missing piece, and that putting that together with fundamental human rights on the international level is very powerful, because international law gives you a way to challenge your own government, gives you a way to say, a standpoint from which to criticize your own country's law. And I'll talk about what I'm going to call critical standpoint protagonism. What I mean by standpoint protagonism is, for instance, standpoint theory that I know of from feminism says it makes a difference, you know, if women were historically excluded from creating the laws are going to reflect a men's perspective. By analogy, if people who were being labeled as crazy have always been excluded from creating the laws, especially the laws that were being made about us and that have oppressed us and that have been used against us, have been used to legitimize these acts of violence against us. What would be the difference if we're the ones making the laws and we're turning it on its head and we're saying, we're naming it as discrimination against us and we're defining our human rights? So when I set out the advocacy for the World Network, the initial outline of it, it began by saying we define our human rights. Okay, so here I've got, I never really always know where I'm going. Then I look at the slide and I see, okay, this is what's coming next. So a little bit more on disability non-discrimination, because sometimes we're resistant and really do not agree with thinking of ourselves as being disabled if we're people who have been labeled by psychiatry. We reject the idea that there is any such thing as an actual mental illness. Many of us do reject that idea, saying, you know, whatever's going on with me, you don't get to label it. I get to talk about my own experience if and when and how and to whom I choose to share that, but not to be labeled from the outside. And so it's you know, the concept of what are we talking about when we say it's disability non-discrimination. One of the ways we've handled that is to talk about actual or perceived disability. That for many of us, if we don't agree that there is any such thing as mental illness, if we don't agree that we have any actual disability, we know that we're being perceived as disabled. We're being perceived as if there's something wrong with us. And it's that label, something wrong with you, whether they label it schizophrenia or bipolar or whatever it is that they're sticking on us. They're thinking of us as a person with a disability, and based on that, subjecting us to very you know, harmful, to acts of violence, to acts of discrimination. So we've developed that concept of perceived disability. That's actually in many national legislations. It's in the United States Americans with Disabilities Act, and it was in a disability international standard that came before the CRPD called the Standard Rules on the Equalization of Opportunities for Persons with Disabilities. Other ways that I understand this, you know, seeing it as, as disability, the emotional or mental state of being of a person has an impact on their desired, can have an impact on their desired activities and participation. Some of us identify with that as feeling like, you know, I need some accommodation here. I need to live my life in a different way because some of these states of being that I get into have a very intense impact on my life. And, you know, people may experience that they need some kind of support in their life to deal with that, and that they want it to be recognized. And as I was saying, mental illness as a concept has been used as a performative utterance to justify segregation, objectification, and violence. Performative utterance, when a psychiatrist labels you, it's not just his opinion, you know, and by extent, it has a potential legal force for a psychiatrist to label you as mentally ill, because it means he or she might be thinking of having you committed. It means he or she might be thinking, I have to evaluate whether this person is a danger to herself or others, and therefore commit them. It's not just like, oh, I think you're crazy, you know? And then by extension, if any of us wants to use that against a friend, a neighbor, a family member, we take on some of that power that the psychiatrists have. And I believe, of course, it's a power that we should all completely reject, and psychiatrists should completely reject it. And what we've put into the CRPD is essentially an obligation on governments to eliminate that power from the law. So we want to counter discrimination by politicizing it, by naming it, and making it a political issue, not something that is just operating undercover to keep denying us our rights. So the problem is not the experience of distress or the heightened state of consciousness, but society's response to it. That's just the social model of disability, really, saying it's society's response that's the problem. It's not diverse minds that are the problem, but the disparity of power in asserting the validity of our will and preferences. That gets into the question of legal capacity. Can talk about that later. And it's not personal differences that are the problem. It's not whether I have a conflict with my mother or my spouse or my neighbor that's a problem. It's whether my neighbor or my spouse is going to weaponize a disability label of mental illness against me, or whether I'm going to weaponize that label against her. And can we resolve our conflicts without using those labels as weapons? Is this, oh, okay, I don't know why it's easier for me to just do it that way. Oops. Okay, so to get now to how we frame the rights in the convention. Okay, I'm going to start with liberty and security of the person, and if this is going to work, I'm going to see if it's going. Oh, it's not going to work. Okay, I was hoping that it was going to just take me to click on that link and see the text of Article 14. The important part of the text of Article 14 says that states must ensure that in no case shall the existence of a disability justify a deprivation of liberty. And it's a little bit convoluted, but it means that you can't have a system of deprivation of liberty that's based on the existence of a person's disability or the alleged existence of a person's disability. In the jurisprudence, in the official interpretation by the monitoring body, that has been interpreted to mean that mental health services must be based only on the free and informed consent of the person concerned. Governments have an obligation to release anyone who is confined in a mental health facility. They've said it in all different kinds of ways, but it's very clear that, as I've written here, mental health lockup is a form of de jure discrimination based on actual or perceived disability. They've named it as a form of arbitrary detention. It's discriminatory, therefore it's arbitrary detention, which is a very serious violation of international law. And I'm combining the way we frame it and what's actually in the text. I have some quotes a little bit later on from the jurisprudence of the treaty body, the Committee on the Rights of Persons with Disabilities, which is the authoritative committee of experts that monitors compliance with this convention. The next right or issue is freedom from torture. That is effectively in the convention in two ways. Articles 15, 16, and 17 generally address the right to be free from torture, cruel, inhuman, or degrading treatment or punishment, freedom from exploitation, violence, and abuse, and the right to respect for the person's physical and mental integrity. And it addresses the obligations of governments to ensure that people with disabilities are guaranteed those rights and freedoms on an equal basis with others. That's very general. It does not say anything about forced psychiatry per se. For that reason, we were also very careful to ensure that Article 25 came in on health with a provision on free and informed consent. Okay, so what I have here, I apologize for not being able to go to the text that I was hoping to do, and that may make it a little confusing, but what I have here about the freedom from torture is the way that we frame it, and that has been picked up by UN experts, at one point by a UN Special Rapporteur on Torture, Manfred Novak, and I think that I may have some references to him in there too. So forced drugging and forced electroshock fit the international criteria for torture and violate bodily autonomy. It's clear that they violate bodily autonomy. The international criteria for torture, that gets a little bit more complicated, but I have written a paper on that, and it has to do with infliction of pain, of severe mental or physical pain or suffering. That's intentional in the sense the act was intentional, and it's done for purposes such as coercion, intimidation, punishment, interrogation, or for any reason based on discrimination of any kind. I have that, I'm sorry. And so we don't have time to get into all the details of that. It's certainly something I've addressed at length and am interested in talking to anyone who wants to go there. States are responsible for the fact that they enact these laws that actually give permission to psychiatrists and to whoever is carrying out the orders of psychiatrists to inflict this suffering, to inflict this violence on our bodies, to whether it's in the form of injecting a neuroleptic against the person's will, strapping the person down and giving them electroshocks they don't want, threatening them that if you don't take this neuroleptic, we are going to hold you down, strip you, inject you, and then the person puts it into their own mouth. That's an act of violence, because it's an act of violence to be subjecting your body to a mind-altering drug that's going to do all kinds of horrible things to you that you don't want against your will, because someone is threatening you. So states are responsible for giving psychiatrists and everyone under psychiatrists who carries out their orders the legal permission to carry out these acts of violence. Psychiatrists are definitely on notice that the individual refuses when the person says no, or they do not inquire They may just do it against your will without asking, or deliberately use threats, and they maintain a coercive environment that is implicitly threatening. So you know, if you see someone else over there in a straitjacket because she refused drugs, you know, I better put this in my own mouth. And that's an act of violence that they are committing against the person. Okay, and free and informed consent in healthcare is explicitly in the text. Oh, I will also say the Committee on the Rights of Persons with Disabilities has accepted in their jurisprudence that forced treatment is one of the violations of Article 15, which prohibits, which guarantees the freedom from torture and other acts of ill treatment. Okay. How am I doing on time?
You have 20 minutes.
Okay. Okay. To go on with framing the rights, equal recognition before the law is a very important right that underpins all the others. And that's where you find the right to legal capacity. And again, I apologize for not being able to link to the text. Article 12, paragraph 2 requires that states recognize that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life. Legal capacity is what gives us the right to make our own decisions, and it does specify all aspects of life, so it clearly includes the right to make our own decisions. Please wait till later. The right to make our own decisions about treatment. And that's in the committee's jurisprudence very clearly, that it includes the right to make our own decisions about mental health treatment or any other kind of treatment. I guess there's other, Article 12 also requires states to provide access to support that people may require in exercising their legal capacity, and sets out that there must be safeguards to prevent abuse, and such safeguards must ensure that any measure related to the exercise of legal capacity respects the rights, will, and preferences of the person. So with all the various elements that are in there, the cornerstone of the right to legal capacity is the respect for the will and preferences of the person. So any measures relating to the exercise of legal capacity can only be supportive to the person's exercise. If the person refuses, if the person refuses such support, they must respect the person's will. And that is the way that the Committee on the Rights of Persons with Disabilities has interpreted this, that there can be no substituted decision-making, only providing support, and the person always has a right to refuse any support they don't want and simply say, no, I'm going to claim my right to exercise legal capacity and not take advantage of support. And that is always the person's own decision. Okay, so it prohibits both long and short-term plenary and partial restrictions of legal capacity, and even any de facto imposition of other person's will that is done that is done in a way that is, for your supposed best interest, because we're constantly, people are constantly involved in interaction. So it's not necessarily against your legal capacity if we're having a disagreement about, let's say, who's going to use the bathroom first, and if I get there first, am I taking away your legal capacity? No, that's not what we're talking about. But it's about imposing if you are imposing your will on me because you think you know how to run my life better than I do, because you think you're going to decide for me something I have a right to decide for myself. Okay, I think for some of these others, it's better to, okay, I'll just say that the way we see it, support in decision-making, if the person wants it, is a positive good, and it's an entitlement. That's why we wanted to have the right to support in the convention. It's okay to say, I need help in making these decisions. I need help in understanding these things. I need help in expressing myself. And you should have it. What's not acceptable is for somebody to say, you need support, I'm going to give it to you, and I'm going to take away your power to decide for yourself. And we'll see more about mental capacity later in the jurisprudence. Lastly, framing the rights, equality and non-discrimination in all of the rights, and transversal relevance to users and survivors of psychiatry, that the whole text needed to be relevant to us. Okay. Here I have a slide on what I was calling standpoint protagonism, but I'm going to skip that because I've pretty much explained. It's really, I think I've pretty much explained that. And I'm really going to go to the jurisprudence to show you what the committee has said. So, I'm highlighting a few of the things they've said related to the abolition of forced psychiatry, the abolition of commitment, and forced treatment in the mental health system, or forced interventions. Involuntary commitment in mental health facilities carries with it the denial of the person's legal capacity to decide about care, treatment, and admission to a hospital or institution, and therefore violates Article 12, legal capacity, in conjunction with Article 14, liberty and security of the person. States parties must abolish policies and legislative provisions that allow or perpetrate forced treatment, as it is an ongoing violation found in mental health laws across the globe, despite empirical evidence indicating its lack of effectiveness and the views of people using mental health systems who have experienced deep pain and trauma as a result of forced treatment. Forced treatment, seclusion, and physical, chemical, and mechanic restraints are not consistent with the prohibition of torture and other ill treatment. Thanks. Here they've said states must release all individuals who are being confined against their will in mental health services or other disability-specific forms of deprivation of liberty. Legislation of several states' parties, including mental health laws, provide instances, that's about the danger standard, provide instances in which people may be detained on the grounds of actual or perceived impairment, providing there are other reasons, including that they are deemed dangerous, and this also is incompatible with Article 14, it's discriminatory. I'm going to go to this one on mental capacity. So, the concept of legal capacity, as I've been explaining it, is about the right to make decisions. Now, we know in our national laws and practices, people are being deprived of the right to make decisions because someone, whether it's a judge or a psychiatrist or some other kind of decision maker, is deciding that they lack the capacity to make decisions. Now, the term capacity is actually being used there in two different ways, because there's legal capacity, that's a status that either you have or you don't have, but it's not about your abilities. Like, do I have the ability to, do I have the ability to run a mile? I may not have. There's the question of abilities of the person, and there's the question of abilities in terms of what the law actually recognizes them as being able to do. So legal capacity is what the law recognizes you as being able to do. The concept of mental capacity is, you know, as the committee says, it's controversial in and of itself, and that is used to refer to a person's decision-making skills, and that's, you know, somebody's judgment about your decision-making skills or how you experience it yourself. So the committee has said that legal capacity and mental capacity are distinct concepts, and in most of the state party reports that the committee has examined, the concepts of mental and legal capacity have been conflated so that where a person is considered to have impaired decision-making skills, his or her legal capacity to make a particular decision is consequently removed. And they're saying that all of the approaches to depriving someone of their capacity to make any particular decision is a discriminatory denial of legal capacity, and instead they say support must be provided. And that support is always, and I didn't include that, but that is, I didn't include that in there, but there is part of that same document, General Comment Number 1 on Article 12, that specifies that people have the right to refuse support at any time. So support is provided for, is offered to the person, states are required to make it available, and they're required to ensure that in everything done related to the person's legal capacity, if someone is going to do a treatment on you and they're required to get your consent. So in all those matters, that's a measure related to the exercise of legal capacity. When a doctor is seeking your free and informed consent to do a treatment on you, it's a measure related to the exercise of legal capacity. And states are required to ensure that that doctor is respecting your right and respecting your will and preferences. That's the way that that is interpreted and understood. So I'm sorry, I apologize for not having the text available. I hope we're getting through this. So the CRPD and Canada made a conditional reservation on Article 12, in effect stating their intent to maintain substitute decision-making if the committee should interpret Article 12 to prohibit it. The committee has interpreted Article 12 to prohibit substitute decision-making, and so now we're in a position of saying, well, okay, what is Canada going to do? The CRPD committee reviewed Canada last year. Among other things, of course, they're encouraging Canada to withdraw this declaration and reservation on Article 12 and to bring federal, provincial, and territorial law into line with Article 12 and General Comment Number 1, which is the document that some of those excerpts came from. They're asking Canada to make budget allocations, to strengthen advocacy roles of organizations of people with psychosocial disabilities, referring to users and survivors of psychiatry, and other marginalized constituencies of people with disabilities, to review federal, provincial, and territorial policies and bring them in line with the guidelines on Article 14, which is the other main document that I was reading some excerpts from. So sometimes they get a little bit general when they're making these recommendations to particular countries. Instead of repeating themselves over and over again and saying, you must, you, Canada, must make sure everybody's released from a mental health facility, you, Canada, must stop substitute decision-making, they refer to these documents and, they say, bring your laws in line bring your laws and policies in line with what we have already set out here, which makes explicit the obligation to eliminate substitute decision-making and to eliminate forced treatment in mental health and involuntary commitments in mental health. Let's see what else I have. Okay. I'll go for this one first.
6 minutes.
Okay. I'm going to have, I want to read out some of this because the United Nations, maybe should I do the other one again? I don't know. Okay, I'll say a little bit of this one and then what the UN has said. This is an article just recently written on Mad in America by a young man who identifies as both mad and neurodivergent and is talking about abolition of forced psychiatry and abolition of all the coercive aspects of the mental health system. Now, there may be some of these things, different ones of us might agree with or disagree with, but he's setting out things like housing first with no strings attached. Service providers would be trained to consider doing nothing as a valid option, to just not panic when a person is going through whatever they're going through. No one would be deemed incompetent. Replace psychiatry with mad studies and neurodivergent studies. Instead of looking at us from a perspective of what's wrong with you, look at people from a perspective of what is their lived experience as they see it. Every program that recommends drugs would also offer support for quitting drugs. All psychiatric diagnoses would be recognized as bunk and removed from medical records. Certainly if diagnoses are being applied to you and you experience it as dehumanizing, as many of us do, it shouldn't stay on your medical record and be something that follows you throughout life, as something that somebody is name-calling you, and then all the other doctors that you go to visit are going to judge you by somebody else's name-calling of you 25 years ago. And any use of force in a psychiatric context would be illegal. Social Security would be replaced with Social Security being our disability pension would be replaced with universal basic income. So sometimes I put this here to say that envisioning abolition of forced psychiatry and the whole forced and dehumanizing mental health system the way it exists today really gets us into some very big picture things, like universal basic income, like restorative justice. How do we really want society to look, starting from a standpoint of a particular segment of society, or a particular really cross-cutting segment of society that has been oppressed, building it from the ground up, from a vision of people who have been subjected to these human rights violations. And I wanted to close with this, a UN call for remedies. This actually appeared first in a document put out by the Working Group on Arbitrary Detention. A colleague and I contributed some to this, and they took it up, and then the Committee on the Rights of Persons with Disabilities included it in their guidelines on Article 14. Oh, I actually do have one other slide after it, but we'll see, maybe I won't even go to that. So they say individuals, and I put it here, well, you'll see, individuals who are currently detained in a psychiatric hospital or a similar institution and or subjected to forced treatment, or who may be so detained or forcibly treated in the future, must be informed about ways they can effectively and promptly secure their release, including injunctive relief. So it's saying this is what courts should be able to do. That courts should be able, courts and the state, as a matter of policy, should be able to provide an avenue for anybody who's currently locked up in psychiatry or being forcibly treated to go to a court and demand and effectively get their release. And it should include injunctive relief that can also be more systemic. Such relief should consist of an order requiring the facility to release the person immediately and to cease forced treatment, as well as systemic measures such as, and the systemic measures are what I wanted to call attention to, requiring mental health facilities to unlock their doors and inform persons of their right to leave, establishing a public authority to provide access to housing, means of subsistence, and other forms of economic and social support in order to facilitate deinstitutionalization. Okay, well, yeah. Such assistance programs should not be centered on the provision of mental health services or treatment, but on free and affordable community-based services, including alternatives that are free from medical diagnosis and interventions, access to medications, and assistance in withdrawing from medications should be made available for those who so decide. So I don't know if that just got, I probably could have broken up the text to make it clearer, but they're taking up some of those are some of the kinds of steps that could be put in place if our policymakers and legislators were willing to envision it. To, first of all, just allow everybody to leave. If I want to leave, where I go is my business. If I have a place to go, great. If I simply prefer to be anywhere but the psychiatric ward, that's okay too. And they do need to provide people with some kind of assistance. Like if they're releasing someone from any kind of confinement, states that the state is sponsored, they have an obligation to provide you with some assistance to start a life in the community, since they were the ones who took away your liberty. So that's the kind of framework that we're trying to propose there. And that's just another way of trying to envision what it could look like if we actually put this into practice. Okay, so I'm going to close, and I have a slide for presenter resources that you can take down if you want to be in touch with me, or you want to check out my website, you want to check out the UN website. Thank you.
Thank you so much, Tina. We'll just have a short break now if you want to stretch your legs or use the restroom. And this is a time, if you haven't already written down a question, if you have one, please go ahead and do that, and they'll be collected. And